continuing on. We're still on Handout 9. We're about 2/3 of the way down the first page, talking about purchase and sales agreements. And again, the point of the purchase and sales agreement is to get us from the point in time where the buyer and the seller decide, yes, we want to do this deal, we want to enter into this transaction, to the ultimate goal, which is called a closing, at which the title to the property and the money changes hands and everything is complete. In Rhode Island, several things come into play. Because of a great deal of consumer fraud in the middle and early parts of the 20th century, the Rhode Island legislature has enacted a whole series of laws controlling these transactions. And several of them are particularly applied to residential transactions. In Rhode Island, if you are selling a property that is a 1 to 4 family residential property, or could even have a commercial unit in it, but if it has up to 3 residential units as well, then the seller must complete something called a Rhode Island residential disclosure. This document has a listing of all different things about the property, conditions, the amount of taxes, whether you're connected to public water or sewer, and the seller is obligated to fill this out to the best of their knowledge, and at the point when a purchase and sales agreement is to be signed, the signed copy of this must be handed to the buyers, who then sign another copy of it to prove that they actually received it. And this basically sets out for the buyers a roadmap as to the conditions of the property. This was enacted about 20 years ago, and it is universal at this point in terms of real estate transactions. Another document that has to be provided to the buyers in addition to the purchase and sales agreement itself are lead paint disclosures. Lead paint was very common up until the early 1970s. Lead was used as an agent to fix paint to surfaces and also to give it the high gloss shine that people often like on moldings and cabinets and things like that. Only it was discovered that as the paint chipped or as it wore through friction of being touched or with windows being pushed up and down, it created dust that could be ingested by children. And it was discovered in the last century that this was very harmful to young children, in particular below the age of 6. So the federal government and then the state of Rhode Island, following that lead, have imposed restrictions on the use of lead paint. Lead paint can no longer be used in residential situations. But the housing stock in Rhode Island, large portion of it, probably majority of it, is older than the 1970s, so properties do contain lead paint. There is a notification that has to be filled out where the seller has to notify the buyer if they believe there's any lead paint on the premises, in particular if any child has ever been poisoned or if any remediation work or testing has ever been done. Those items have to be provided to the buyer. Now, getting back to the purchase and sales agreement itself, several things must be present to make it valid. First of all, we need the names of the parties. We need to know who the buyer and who the seller are. We need to clearly identify the property. In Rhode Island, identification of the property is done by mailing address, street address, and then by something called the tax assessor's plat and lot number. In every city and town in Rhode Island, the tax assessor has given a key number to each parcel of real estate, and usually they are identified by a map of an area of the town that has a number, and then every lot on that map has a number for that lot. So that is commonly used in Rhode Island. In Massachusetts, they're somewhat pickier. In Massachusetts, the real estate agreements will have the address and will have the plat and lot numbers sometimes, but they prefer and almost universally require that the book and page number of the deed into the present owners. And the book and page number is generated by the county of Massachusetts. When you buy property, you must take your deed and record it in the county courthouse for the transaction to be final. They assign a book and page number to it so that a copy of it goes into the indexes and can be found by anybody in the public after that. And that reference must be in your purchase and sales agreement in Massachusetts for it to be valid. Finally, the Purchase price must be listed. The courts, again, will not guess the price. If any of you took my contracts course, you will know that courts are loath to pick a price, pick a value for the contract. That's the whole point of the contract, is the parties are trying to decide that among themselves. And finally, signatures. And because both parties are giving up and getting rights, this is a traditional contract situation with some consideration. We need the signature of both parties on this contract, because either side could end up suing the other and would want to get the transaction into court, which under the statute of frauds can only be done with a writing and with a signature. As we go through this process, we're going to find out that many real estate documents only require the signature of one of the parties, which seems strange to our way of creating contracts in the modern world. But again, you only need the party that you might want to sue. You only need their signature on a document. So notes and mortgages and some other documents only require one signature. Purchase and sales agreements require two. Some of the provisions of a purchase and sales agreement. Normally, a deposit will be given at this point. It is generally held by the real estate agents, although if there are attorneys involved, sometimes it will be held by the attorneys. Normally, a deposit will be 5% of the purchase price. So that's $5,000 for every $100,000 of the transaction. This is a form of what's called liquidated damages. Liquidated damages are basically damages that are assessed in advance in case a party breaches. We basically know what it will cost them to breach. The liquidated damages work in favor of the seller. For if you're a buyer, you tie a seller up for 6 or 9 weeks trying to get your financing, trying to make this deal go through, and then you walk away, you have cost the seller time and money, but it's very difficult in most situations to put a set number on that or then to chase the buyer to get that back. So these contracts are written requiring the buyers to put down a significant amount of money when the contract is signed, and if the buyer chooses to disappear from the transaction without a legal reason for doing so, then the immediate first damage is that the seller gets to keep the deposit as liquidated damages, as basically damages assessed in advance. This does not prevent the seller from attempting to get other damages, which would be normal contract damages, such as if they end up selling the house for less money, the buyer who walked away could be sued for the difference in the purchase prices between their agreement and the subsequent agreement. A phrase, time is of the essence, is a critical thing to understand when you're making these contracts. Normally, contract law says that even though we put a date in a contract, the parties have a reasonable time to perform. What is a reasonable time? I call reasonable in contract law my elastic band word, because it changes from situation to situation, and in purchasing a piece of property that can cost $250,000 or $500,000, what might a court deem to be reasonable? It might be weeks or months. If you want the transaction to happen exactly at the time it is supposed to happen, you must use the magic words, time is of the essence, in the agreement. It's one of the few sets of magic words left in the law. If a contract is of the essence, and in Massachusetts in particular, we put it right down to the time of day we're going to appear at the registry on the set closing date to exchange the deed and the money. If either side doesn't meet that deadline, they have technically breached the contract and damages can apply. In Massachusetts, every purchase and sales agreement time is of the essence. In Rhode Island, the real estate agents and Rhode Islanders in general are more laid back. They don't like that. So when we try to put time is of the essence in a contract in Rhode Island, we tend to get a lot of pushback. The realtors don't like it. The parties don't like it. But if one party's not ready to go on the set date, that means they have an unspecified amount of reasonable time to continue trying to put the deal together, which very often causes a great amount of aggravation and grief for the other side. But those are the rules of contract law. And what happens with purchase and sales agreements is we have a weird blending of real estate law and contract law. So you really need to be aware of both sets of laws to know what you're doing in this area. I am up on my 10-minute mark, so I'll stop again and we'll carry on in part 3.